right to the punch here. Working on some music right now. I don't have music without getting in copyright infringement and taking people's stuff. But there is some music that I can do that, but I haven't qualified that yet. So let's get right to this thing. Tonight's going to be one heck of a night, and we're going to deal with specific objections. Make sure my mic's all worked out here. Just getting set up here. So it's 9 o'clock, 12/4/2015. And I want to go right to, see where we at here. I'm going to shrink that down. Go right to this and get this out of the way. I object radio broadcast. You are tuning into I object internet broadcast. Our freedom, family, property, and life-saving topics are on government waste, fraud, crimes, and among many other things. I object radio is for pro se, pro per, biblical education training and entertainment value. I don't give legal advice. But if you need training by our educational classes or emergency tutoring, please tell me ASAP, as soon as possible. The phone number is 740-824-4850. Phone number 740-824-4850. Remember, educational information and legal advice are two different categories of information. And I think I'll just highlight that for and save that. If you need legal advice, go somewhere else. I can't help. I think I'll give that a straight statement, if you will. Nevertheless, are you tired of being a slave, serf subject, and you want your freedom and rights? Call the school. 740-824-4850. Now, this kind of standard, I do this all the time. I say this all the time, and I go through this. You can see it. So it's on the video. But it has real meaning and substance. It does something. It means something. It performs. It's like an engine. You put the key in ignition, turn it, it goes. And we're going to talk about trends tonight and objections. And we're going to split it up into something else that's happening that plays into this. So it's a three-way play into a part, but it splits up in two categories of information. And I want you to think about research and how categories of information merge together. Okay? So just bear with me. Remember, government, its agents, officers break the rules and law all the time. Contact the school, 740-824-4850. Or send an email to commonlawradio@inbox.com. commonlawradio@inbox.com. Thanks. I'm going to exile that. Let's go over here and let me find this other document. Like I said, I got in here a little bit late. I'm not going to go into this because this is kind of lengthy. It's 2 pages. All broadcasts shall be based on past, present, and coming wars against your rights, aka trends. See this trends right here? We're going to be talking about this trends. I'm going to show you a trend. And this trend's been going on since 1980. But it's really climaxing. It's been steadily moving, and I'll show you the trend. Now, this is exciting. I'm very excited about it, but I'm excited and I'm hopeful and I'm at peace with it, and it makes sense to me, and it does nothing but aid my research, my skills, my knowledge, understanding, and I pass it on to my students and the listeners. So, aka trends in the news or courts. And Craig will be teaching how to stop these trends by protecting our rights and staying out of jail or prison. A lot of the patriots, man, are getting jammed up, indicted, going to prison. I mean, they are just getting raked, brutally slaughtered. And they never once figured out how to properly understood what the court was saying or try to move the court. I can't tell you any specific thing, but my class gives you the overall program, how I do it, and the way I think about it. And I made videos, MP3s, and I have working material in here that works. And we're going to be talking about federal objections tonight. And Craig will be, that be me, teaching how to stop these trends by protecting our rights, staying out of jail or prison. If we can stay out of jail or prison, maintain our life, liberty, and pursuit of happiness. That's the goal. We want to stay out of the traps. A lot of doctrine of Balaam traps out there. A lot of them. A lot of patriots practicing traps. There's think tanks on Skype right now that I know of that kicked me out because I was moving my class trying to tell people. All they do is talk about the government corporation and the Uniform Commercial Code and all the things. The sad thing is they don't know how to put it in operation. And they never will. They come up with all these theories, hypotheses, and fictions and conspiracies and all these things, and they can't really prove them. They put a lot of things together, but it's still just completely off-point weak, has nothing to do with the case specifically, and they believe, and I'm going to tell you right now, they believe themselves, okay, they themselves believe that this research and education that they're doing and teaching people, believe that could stop a case. They believe that. But they don't understand the word territory. Like I told Pete Santelli on his silly broadcast, they don't understand the word territory, and they don't understand how many hats the judge is actually wearing. And they surely don't understand the common law. And they get conflicting statements about what common law is from the courts, from the legislatures, from their research, news articles. They see there's no common law, it's this, that, the king, the commercial courts. They have no idea. But yet we got debtors' prisons all over the place. How is that possible? They say, well, the court's a corporation, it's a charter, and the corporation charter's putting you in jail and in prison. That's not true. Because they never looked at the legislative language, words and phrases. They never paid attention to the very substance. The crank, rods, pistons, camshaft, bearings, rod caps, main caps, harmonic balancer, the pulleys, the head, the intake, the fuel injection system, the exhaust manifold, all the things that make that motor, the oil pump, the pan, timing chain or belt, pulleys, oil, transmission fluid. They never looked at the guts of the transmission or the guts of the very guts of the engine, being the language of the statute, how the court came into being. They didn't, and they surely didn't look at the year. And they can't get past the year. And there's a succession of years from the 1700s or 1800s, early 1800s for Ohio, clear up to 2015, and they never got past that, and they can't figure it out, and it doesn't make any sense to them. So the only thing they go is to Dun & Bradstreet and say, see, it's a corporation. Well, it's a corporation because it falls under the Federal Reserve Act. That's a crime. That's true. But that's as far as it goes, because that court was created by the legislature in the 1800s. And we didn't have the Federal Reserve in the 1800s. And we didn't have the corporation organizational structure. And then they want to say, well, it flipped over, it changed. Well, it's kind of true, but it's not, because we have a chain succession of never being overthrown. And our courts have stayed the same. And no matter what Pete Santelli tells about that ignorant patriot stuff, that's not true. It's not true. So I'm going to talk about trends tonight. This includes keeping our religious freedoms, family life, and property rights intact. For most, winning the battle with the classes only and wars within our reach. You have no idea the power, the rights you got. And you know the thing about it is that the patriots always have this acidic dispositive or acidic prove a negative. That makes no sense. And they can't demur for the life. None of them can demur. I haven't seen one patriot take patriot mythology and able to demur successfully. Well, the judge ran out of the courtroom. Why? Who in the hell wants the judge to run? I need that court order. What kind of lunacy is this? I thought I'd share that with you, brothers and sisters. What kind of lunacy, insanity is this? I don't want that judge to run out. I need my court order so I can file my lawsuit, collect money, change policy, take the county where I want it to go for our rights, take the state, create positive case law, not this patriot acidic negative, proven negative case law. Patriot always being put in a category of the patriot negative. You have a right to travel without a license in an automobile, and the Supreme Court said so in Anton Jones' GPS case. They said so. You have a right to travel in an automobile without a license and plates. They said so, but the thing of the qualifier is with that is that there's some public safety and the possessory interest and some other things that the state and you got to settle because it's not in the legislation, it's not in the statute. We need to understand that. Pete Santelli didn't tell you that. Pete Santelli doesn't know that, doesn't understand that. I like Alex Jones, he's pretty cool, but he doesn't understand it, he never said it. But that's fine. I like listening to Alex. I don't like Pete. Alex does a hell of a job. Pete just sucks. Pete Santelli's a clown. I don't like the guy. And I don't hate him personally. I just don't like the way he presents these data. It just makes no sense. A lot of patriots don't know that either. And they don't understand common law and technical trespasses. They don't understand that. So without a plate, you still got to pay the money for the usage of the blacktop and road, because it's all everybody's a political tongue-tying organization. Still unjust enrichment, but you can do it. But there's a hell of a fight there, and nobody's pulled that off. Not even myself. But you have the right to do it. The question is, can we pull that off? Do we want to? I'm not so sure we should. Maybe we should. Maybe we shouldn't. I don't know. There's a lot of security issues there, and responsibility, and you got to be financially responsible, and that's pretty tough the way they got to strap down the Federal Reserve System. We got multiple problems. I'm not for it. I'm just telling you, the roadmap. The case before us is an exceptionally difficult and blood-sucking case before us. So keep that in mind. I'm not for it, but at the same time, I understand it. I understand the mechanics of it and the database material and the copy of the state evidence, and I understand that and the evidence rules about that and how weak that stuff is. You got common law and the evidence rules too. You got hearsay. Nobody's being subpoenaed from the Bureau of Motor Vehicles. You got all kind of problems in the evidence itself. Lewis Ewing talked a little bit about that. All right. Let me go on to finish here. It says, this being said, topics below shall enable you to learn and win from our downloads MP3 YouTube videos. Now, we're not doing MP3s unless I can find another way to do it, because I'm not creating that. It creates too much conflict in software and record. So I'm going to get rid of that for right now. Okay. Please don't sell for profit any of this material. Share with others. Thank you very much. So topics, biblical law, and pleading out the law and rights from a biblical standpoint. Right every time. The common law and code pleading rules. There's code pleading rules, and those code pleading rules were reestablished in 2007. Those code pleading rules were reestablished in 2007. Did you know those code pleading rules were established in 2007? And you know what the cases are? And the court outlined the rules. And a lot of lawyers are saying, who would think we'd go back to the heightened pleading standard? Well, I started off there with George Gordon School of Law. I started off there. I started off with notice pleading, and that stuff sucked. I didn't understand it. But when I got introduced to code pleading, and then I figured out what notice pleading is and where notice pleading comes from Islam. Notice pleading is used to the kafir, against the people of the book and non-Muslims, and take their property and behead them. That's where notice pleading comes from. It's an Islamic practice. Just like Obama says, Islam is at the basis of American jurisprudence. And the other guy, and Shabazz, and the other senator out of Chicago, out of Illinois. He's on my website. Notice pleading, the Islamic pleading practice. You ever heard of notice pleading? Fact pleading. This here is killer. Fact pleading. And every word that proceeds out the mouth of the government shall not return maybe. Shall not return. They always try to return it and twist it. You know how to fact plead out? The judge is trying to change your facts by his ruling. Can you identify the change of facts by the ruling? I can. We're going to do this statute against you because you were driving under suspension. Well, wait a minute. That's not a fact. That's a presumption. Because they never qualified when my rights begin and end, and where I was disabled or under disability. Fictions used by court, or fictions used in court by government, how to spot fictions and defeat them on record, including with lawsuits. Constitutional law and nuts and bolts, how it works. Nobody's teaching this. They said, well, the Constitution doesn't apply. Really? We're gonna take a look at this. I'm going to show you something tonight very shocking. And it's happening. It's a trend, and it's been going on for a while. And it's right before us right now. Statutory construction. I have not seen one patriot and I've talked to a lot of patriots. There may be one or two out there, or some, maybe a lot. I don't know, but I haven't seen them talk about statutory construction. They have no idea how this works and why. This is the very nature. The crank, rods, pistons, the oil pan, the oil pump, the caps, all the things of the internal guts of that engine / statute. Do you know what this is? I teach this in my class. It's a very big deal. Words of art is a double-edged sword. Without this, statutes are junk law. All right, courtroom procedures by mouth, courtroom procedures in chamber, ex parte hearings. This here is an egregious mess. Courtroom procedures by motion with briefs and support. Exhibits. Do you know there's rules for exhibits? Affidavits spotting crimes, crimes and more crimes. Now I'm not going to read all this because we got a lot to do tonight, but I'm going to have this uploaded tonight. You can go to the front page, download this, and we'll go from there. You can take a look at this. This is some of the stuff that we're going to be talking about tonight. In all of our shows, I'm going to be hitting the classes, and we're going to be dealing with this stuff. I got one for you. Have you ever heard of a tax taking? Federal Reserve System and real lawsuits against said government for tax taking. Do you know what a tax taking is? You ever heard of it? Google up, Google Scholar, type in tax takings or takings. Now apply it to taxes. Tax takings. Now, I heard about this a long time ago, and it's been in my mind for a long time. A law professor out of, I want to say out of Missouri. And he's a constitutional, he's a liberal Democrat constitutional scholar, and he is just phenomenal. And he's the one that introduced me to tax takings in a video. And I went and explored that, and I saved a lot of material on that. One night we're going to get to this, tax takings. The government commits takings by taxes. They convert a tax which may be legal, lawful, and legitimate, according to them, not from all the things that we know or talk about. Just for sake's argument, for them. Let them say it's legal, lawful, and legitimate. Okay, fine. They take a tax. They're allowed to take a tax. But then they take the tax and convert it into a takings statutory common law crime against the citizenry. Do you know how to spot it and why? You know it's illegal to do that. You have a right to not be taxed. The government has no duty to create a system that compels you and puts you into bond servitude or slavery in the 13th Amendment. It's a takings. I just gave you the answer. The answer is 13th Amendment for slavery. The government created a system with the Federal Reserve, and they convert the tax, which is legal, taxing a power under the Constitution. The power to tax falls under the Commerce Clause and the police power. Okay, Commerce Clause says, okay, we're going to create a Federal Reserve System or whatever paper money system we had from the beginning of the Republic to now. They're allowed to borrow. That's what they say in the Constitution. But did you know that provision, when it threatens the national security, is a national security violation, and Congress is devoid of such power. If Congress threatens the law and threatens the nation, the tax system and the Commerce Clause being applied that way violates the police powers. And they convert the tax into takings. That's all I'm going to say on that. Okay? So, I'm going to save that. Civil rights lawsuits, a neat body of tort law. We need to learn this. That's what I teach. I'm doing a class right now on this. It's time to get paid. Forget this research and these silly, stupid think tanks and Skype, and I'm going to study the UCC. Forget that. Let's start suing and make money. Because all that time you're spending, you're not making a dime. It's like pissing in a barn fan. You walk up to a 74-inch barn fan and you pissed right in it. Now you're in trouble and you got urine all over you. That's all that does. It doesn't teach you how to file a lawsuit. You can't. We want to file lawsuits. It works. Time to sue again. So contact the school 740-824-4850. Now let's move forward here. All right, very interesting stuff. Very, very interesting stuff. Where I'm at here. I'm going to close this out. Okay. So take a look at the Kirk website, the Craig Kirk School of Law, the Kirk website here. That's my site. And look at some of the links. And I have a lot of links in here talking about things. In every one of these links, there's a way to get into a lawsuit and research and get the vaccine. How to get doctors in a world of hurt with the state, filing crimes, committing perjury, Medicaid, Medicare fraud, under Title 42, how to catch them committing fraud and stealing. Okay, water rights. Every one of these pages opens the door. GMO poison page. You know, suing farmers who plant GMO, who are advocates for did I do that? Oh, I gotta stop that. Who are advocates for Monsanto or other, how to sue farmers. You know, farmers are easy to sue. You know that? Monsanto wants to come in there and represent them. All you need is a couple winter cases. All this stuff, geoengineering. There's lawsuits going on with that right now. Take the suit, file it. DA medical records, crimes against you. You know, DEA commits medical records crimes. The FDA so far. Big Pharma, biblical surviving of family, biblical surviving of farming. That's a different animal. Rights and freedoms, citizenship. What is citizenship? Debt, slaves, oil, gas. Check this page out. Debt, slave, oil, gas. Family rights, marriage. There's a lot of material I still got to put on here. All of this opens the door to start research and building your library and having a library and then sue. And that's what my classes are all about. And as a matter of fact, I'm going to go introduce you to the class real quick here. Here's the class. I object law class. There's 29 chapters in it. Okay? Historical migration. Should all higher governments answers in the Bible. Constitutional research. Trial notebook. Code pleading. Biblical law, legal research and public records, extraordinary remedies, comedy, grand jury, ham on rye, inmates' rights. This is 12 hours, 13 hours. This is important to know. A lot of patriots are getting in jail and getting in trouble, but they have no idea what inmates' rights are and how to spot them. Discovery by statute. So you can take a look here. It's in the video. You can see what's there. Rules of court, so forth. Forms, statutory construction, forms, appeals court, winning transcripts. This here's magnificent, man. Post-conviction relief, closing arguments, objection, cross-examination, direct opening, trial, hearings. All right, I did enough of that. Let's move on here. So call me if you're interested in this class. This is a 3-week class. This is 3 weeks. 3 weeks long. Phone number 740-824-4850. 740-824-4850. Matter of fact, I better turn that up. I'm going to close out of here. Okay, let's move forward. We got a lot of work here. So there's the site. Schedule. Check the schedule. Contact page. If you're interested and want to watch more. I'm going to X this out so I can save some bandwidth and move forward here. You ready? Let's go. Check this out. Remember I said trends. How to spot legal trends. Ready for this? This is on the Examiner. Washington Examiner. And Gartelli, whatever. Anna Gartelli, whatever. 12/2/15/2000. 10:35 p.m. Look at this. Texas sues feds for sending 6 Syrian refugees to Dallas. Say, what's that got to do with anything? Well, we got trends going on here. And if you watched, and I'm going to do some videos on what the military have said about what's going on in the Middle East. Let me tell you a thumbnail. The Middle East, because of the crimes against God himself, crimes against humanity, crimes against the law of nature, and complete utter judgment coming against the Middle East. And oppressing the West, and oppressing the strangers, and murdering the Christians, and raising the caliphate illegally, and practicing walking around Saudi Arabia and Mecca, or whatever that thing is, walking around that thing and going left to right, the stone, all the crimes that they commit, the beheadings, the crimes against the Torah, the crimes against the Bible, crimes against Christians and Jews, the Peshmerga, the Kurds, the crimes against anybody and everybody. They are committing crimes to what Christ said don't do. They are just doing it. The Kuru. Kuru is a brain nervous system disease from cannibalism. In Islamic law, you can eat a kafir, in extreme stress situations to survive. Kuru. Google it up. pedophilia, homosexuality, I mean, wearing dresses, I mean, they went full all-out stupid. ISIS is full all-out stupid, creating a caliphate with Turkey. Antichrist beast, the mixed race. Turkey is a white, dominantly white mixed race, Masonic Islamic nation with nuclear weapons, a NATO partner. I said it first. That's Turkey. You look at their military and look at their uniforms, it's a Western mechanized military, Islamic Republic mechanized military with nuclear weapons. The worst case scenario ever imaginable. All right, Texas Governor Greg Abbott received praise Wednesday. I'm going on to the Examiner now. Okay. Texas Gov Greg Abbott received praise Wednesday for the following through on his promise to sue the federal government if Syrian refugees are resettled in the Lone Star State. One of the major provocations of the Revolutionary War was King George forcing people to house soldiers they did not volunteer to house. Louis Gohmert, Texas, told the Washington Examiner. The president seems to feel the federal government has arrived at the level of royalty that is privileged to force peasants to house whomever it says and wherever it dictates. The federal government and the aid agency International Rescue Committee announced Wednesday plans to transfer six people to Dallas. Okay, I should put this up here. North Africa, the Vatican. Google this up. And I need to go do this. I forgot to do this. This is another part of this. I want to just prop it up side by side, but I didn't do this. North Africa, the Vatican said that if you go on vacation and somebody moves in your property, you lose the right to your property rights, the Vatican. Google that up. I had that on an external drive before, and somehow or another that drive was destroyed. But anyhow, it says, talks about King George, right? Revolutionary War, King George forcing people to house soldiers if they did not volunteer to house. Rep. Louis Gohmert, our Texas, told the Washington Examiner. President seems to feel the government has arrived at the level of royalty that is privileged to force peasants to house whomever it says and wherever it dictates. The federal government and aid agency International Rescue Committee announced Wednesday plans to transfer 6 people to Dallas. All right, we got that out of the way. Is that fair? Is that fair? All right, let me X that. I'm going to go to the next one. Take a look at this. Forfeiture reform laws enforcement agencies receives cash, cars, even homes without ever needing to convict. Okay, this is part of it, but this is a small part. Institute for Justice. You guys see this? Over 100 editorials call for civil forfeiture reform. You seen this? Forfeiture allows law enforcement agencies to seize and keep cash, cars, and even homes without ever needing to convict or charge someone with a crime. To challenge these abusive laws in courtroom and state houses across the country, the Institute for Justice launched an End Forfeiture initiative in 2014. Many laws are in dire need of reform. As AJ found in its new report, Policing for Profit, only 7 states and Washington, D.C. earned a B or better for civil forfeiture laws, and just 2 states, New Mexico and North Carolina, have abolished civil forfeiture. Now you can read this. Go take a look at this. This is part of the whole picture. I'm gonna go here. I forgot to do this. Let's go to Amdur. Go down to, this is my own database part of it. This is just so small. This is database number 2. This is a fresh one. I still got to go through and correct some of this stuff. Where is, let's see here. Bear with me. Okay. Mika's brief. I did this the other night. Okay? I want you to go through this. Watch this. Supreme Court of the United States. It's Mika's brief. U.S. Representatives Trent Franks and so forth, and these guys here. You can read that. I'm not going to read that. Save the wear and tear on me. We're talking about trends, right? People think this is boring. Counsel for Congressional Amicus Curiae. November 25th, 2015. Now, you can go get this yourself, and I'll even show you where to get this. This is important to see this. Look here. U.S. Congressman Louis Gohmert, proudly serving the 1st District of Texas. Oh, let me blow this up a little bit. Louis Gohmert praises amicus brief filed with the U.S. Supreme Court addresses the illegality of revenue-raising Obamacare having originated in the Senate. Go read this. Talks about the origination clause, and it goes clear back to Magna Carta, right? We're talking about trends. So I'm going to X out that. You can go look for yourself. I'm not going to go through this. I'm going to save the wear and tear on me. All right. I'm going to go through the table of contents. Then we'll jump right down to page 17. Table authorities, interest of amicus, introduction, summary argument, D.C. Circuit decision, abrogates whatever the exclusive power of the House to originate all bills for raising revenue, thereby threatening the separation of powers. Now they filed this. A lot of patriots say, well, there's no constitution. It's not in effect. It's a force in effect. And that we got a corporation government, and we got this, and it's a fiction, it's a scam, and we don't have courts, and then not one of them have looked at the language of the territorial language in the statute, and the year in the statute, and pulled the charters clear back to the 1800s. They haven't done that. D.C. Circuit purposive test conflicts with the framers' intent, historical practice, and the opinions of the court, lower federal courts, and state courts. See this? I'm gonna let's see here. What do I need to do? I need to go here, and this Adobe stuff really sucks. I'm gonna X out of this Adobe. I'm gonna X out of that. I'm gonna reopen this to. I'm gonna go here. I'm tired of Adobe. It's just. All right. So I just OCR'd this. So I'm going to go scroll down here why this is doing its thing here. So we got separation of powers. And we got the intent, historical practice, and the opinions of this court, lower federal courts, and state courts. Notice we have all this combined. Notice all this is combined. You got three or four things going on here. Do you notice that? History of the origination clause. Now you can read these cases. Some of these cases go back. This here doesn't have a case number to it or a year. But this is very interesting. Did you notice they left that out? And it's kind of strange. They should have put a year to it. And should have cited what that is. But they didn't want to draw that. They didn't want to raise that for some reason. They should have put that in there. I would have put that in there. But they like these dots. There's a reason for it, but I would have put this, what they're talking about, I would have put it right here and talked about the Magna Carta. Early lower federal court's decisions. I'm going to scroll down here. Look at some of these years. Notice, look here. They're talking about Joseph Story commentaries. Joseph Story? You go into court, and the judge is always talking about Cooley. Judge Cooley. Cooley. But here they cited Joseph Story. You know what Nancy Pelosi said? We got to pass the bill to know what's in it. Is that what Cooley's intended was? Did Cooley's had the intention to do that? Joseph Story repudiate that. He said that was garbage. Joseph Story. Go to Google Books and download Joseph Story if you want to know what's going on here. House bill was not a bill for raising revenue. Okay, so we got the health care bill. We got conclusion appendix, okay? Let me see, what do we got here? Why that's catching up here. Constitutional provision. Massachusetts Constitution, 1870. Litigating this 1870. 1870. Keep going down. 1911. 1882. Well, watch this. There's a the Burrell case. I'm not going to go into that. There's 1916. You say, well, that's after Reconstruction. Okay, that's fair. That's fair. 90s cases, I'm not going to go into those. 1877, 1906, 1897 case, 1936, part of the New Deal. Okay, you say, well, that's a Butler case. Here's a famous case, by the way. Go check it out. Okay, 1875. Look here, United States versus Mayo. I pulled this up and was reading this the other night. 1813. 1650. Now, I talked about this the other night, and what this is going on here. Notice these old-timey numbers. 1813, 1650. Notice, so you think of a freeway. You have a 2-lane, and you want to build a 4 or a 6 or 8-lane freeway. You take the 2-lane, and you merge the two together. Now you've got, just like here in Ohio, we got State Route 16. Turns in, it's a 2-lane, and then it goes into the 4-lane. 4-lane. So they talk about 1860, right? Or, yeah, 1813, 1875, 1650. Now we got a freeway lane that goes clear back to 1650. You with me? I'm going to talk about this trend that's coming up here, and this trend is pretty important. 1818. 1787. This here is pretty interesting. 1969, when they talked about this, the Federalist Papers. Joseph Story Commentaries on the Constitution of the United States, 1833. Okay? So that's opening up. You got some newer stuff that, I'm not going to go into that. Interest of the brief talks about what's going on there. You can read this for yourself. I'm going to go down to page 16, which is 16. The history of the origination clause. Dissenting judges correctly observed that it is difficult. Notice how it is. It's difficult to say with a straight face that a bill raising $473 billion in revenue is not a bill for raising revenue. PAC. The panel's opinion primary purpose test to exempt $473 billion Affordable Care Act from the origination clause is a textbook example of missing the forest for the trees. This is called a legal fiction. This is called a legal fiction. That's what they're calling it. It's a nice word for calling it a lie. Moreover, the primary purpose test is not supported by the history of the origination clause. Quite opposite is true. Now, they just called it out as a lie, and they're saying it's a lie. Few clauses in the Constitution have such a rich and clear historical significance as the origination clause, with its origins in the Magna Carta. The Commons of England fought to preserve and strengthen this right for 500 years before the principle was firmly solidified by the 17th century. In English Parliament custom, no principle's neglect has been as responsible for undermining the legitimacy of the English-speaking governments as the neglect of kings, legislatures, and courts alike of the origination principle. The principle of imposing taxation only by the immediate representatives of the people was so firmly rooted in English tradition that its implementation on the American side of the Atlantic was nearly universal in colony and early state legislatures. Where royal charters did not explicitly guarantee the early American colonists this prerogative, they seized it under various names of the House delegates, Burgundies, whatever, commons, or representatives of the colonialist lower house. These closest to the people were commonly vested with the exclusive right of the clause. Our founders, often the same individuals who worked to draft the state constitutions with the origination clause, enshrined the central principle limitation on governmental power to originate bills for raising revenue. Article 1, Section 7 of the current Constitution. Current Constitution. The lower courts, now look, notice the current Constitution. Now notice this is something they've done clear back to the Magna Carta. Under the clause, though, the lower court's fixation of the precipitation for in the origination clause bills for raising revenue to support its persuasiveness test is a crabbed and historically inaccurate understanding of the clause. The colonists thought that anything that taxed them at all for any reason was a money bill and therefore subject to origination restrictions. All but one of the first 13 states, including the origination clause provision in their respective constitutions, and only one of those pre-ratification constitutions had a purpose reference. The Massachusetts Constitution of 1780 was quite explicit and formed the basis of the imported final language. Note imported. Final language. All laws adopted. Final language of the federal clause. No subsidiary charge, tax, impost, or duties ought to be established, fixed, and levied under the pretext whatsoever without the... I'm going to finish this here in a minute. Without the consent of the people or the representatives in their legislature. All money bills shall originate in the House of Representatives. This is like Game of Thrones, right? But the Senate may propose or concur with amendments as other bills. More compelling by deleting the words for purpose of revenue in the final version of the origination clause, the framers appear to have decided that the term money bills was the synonym for the bills for raising money without the limiting for the purpose of the revenue clause. Early lower federal decisions. I'm not going to get into this. You can go read this. This is a huge event here. Okay, what are we talking about? Let's go back here and restate this one more time. Texas sues feds for sending 6 Syrian refugees to Dallas. Right? What's he saying? Revolutionary War. King George forcing people to house soldiers they did not volunteer to house. Who are these Syrian people? They're under reparations, right? War, reparations, tearing up Syria, overthrowing Assad, the government. But what's really going on here? What's really going on here? I have a theory, and I'm putting it together. It's pretty solid. On my Islam in America page on the website, you go there and take a look at it. The question is, how far did Islam contaminate American Anglo-Saxon law or our Western law? How far did Islam in this country contaminate and make sick American man of the West? How far did Islam contaminate our system of law? That's the question. You say, well, what's all this got to do? Well, I'm going to show you. So we got civil asset forfeiture. We have this going on here. We have this thing that was just filed the other day. That's the wrong deal here. Where's it at here? We have this here. This is historical. They're going back, predating the United States, to argue this in federal court, the U.S. Supreme Court. Something's going on here. You ever heard of a reset button? This is called a trend. So we got that. We have this brief. We have this. We have forfeiture, taking the property. The police are like the king's soldiers, right? Everybody hates the monarch. Everybody hates the king. But when the police are shooting you, everybody hates that, but they don't know why they're doing that, where that's coming from. We got dual system here. Jacob and Esau. I'm going to go on here and take a look at this. You ready? Here we go. Here's the glitch. I'm going to read this to you. This is incredible stuff. And it started about 1980 for real. Really started heavily in 1980. What else happened in 1980? Mad Mothers. What else happened? Child support. What else happened? The IRS restructuring in the 80s, from 80 to 86. What else happened? The taxes, DUIs, the flipping upside down the country. What happened in 1980? Take a look at this. Trends. You want to know? You want to see how there's a war going on right now in the United States. This is why I call this the objection I object law class. We got to be able to identify what's going on here. Inn of court. Eldon B. Mayon, whatever. American Inn of Court. History of Inn of Court. For more than 6 centuries, 4 English Inns of Court have constituted a judiciary university having the power to call the eligible members to the bar and confer the degree of barrister at law. The societies are to order them according to the custom, those of Lincoln's Inn, Inner Temple, Middle Temple, Gray's Inn. The records of Lincoln's Inn go back to 1422, almost 80 years earlier than any other inns. The records of the Middle Temple and Inner Temples date back to 1501 and 05, respectively, and the records of Gray's Inn go back to 1569. Why did they do this? You got 3 basic reasons. I'll tell you what they did this for. Islamic law infiltrating the West. There's a video. It's 45 minutes. It's by Bill Warner. I'm going to say this right now. Bill Warner, Usama Dakdok, Walid Shubat, and those 3 guys destroyed what we know. Destroyed what we know as the Vatican and the Mark of the Beast Vatican and the temples and the hills and Islam and what happened to the Holy Roman Empire. There's another side to the Holy Roman Empire destruction. Okay, now I told you that the Vatican says if you move out or if you go on vacation, somebody else is in your house, you lose your house, right? The police are taking their house under forfeiture laws. The police are shooting blacks and everybody else in the street for whatever reason. Now that shooting is a complex question. It's not simply, I hate pigs and cops, I want to make pigs and blanket fly and all that. That's just stupid. That's just ignorant ghetto language that don't mean anything. You can't do nothing with it. It's just stupid. You might like it. I don't like it. It doesn't help me understand what's going on here. And how enshrined, what kind of battle's going on here. So we have the Masonic Lodge in the courts. We have the Vatican. We have Catholic and Jesuit judges and Jesuit law schools. George Washington Law School, Washington and Harvard, yeah, whatever. The Jesuit Law School over in St. Louis. We have Protestant law schools. We have a battle jockeying for power. The buildings, housing, and inns are, and I'm going to go back and read this, right? So we have Islam. We have we have the Vatican, civil power, papal power in the courts, maybe, and we have Inn of Court from English, our English courts. I'm siding with the Inns of Court. I'm siding with the rest of the stuff. The patriots are acting like Muslims. A lot of times the patriots are acting like Islam, ISIS, or Muslim, and they don't really know it. They don't understand it. They have no idea. Many times. The buildings, housing, and the Inns of Court are considerably older than records of the inns, and see the origins in settling the estates of various entities. Notice we got entities clear back in. Starting in 1118, in that year, a branch of the Order of the Knights Templar of Solomon, the Templars, settled at Riverside Estate south of Fleet Street in Holborn. Shortly thereafter, Henry Lace, Earl of Lincoln, settled in a estate north of Fleet Street, which extended to High Holborn. Do you know where estates come from? Estates are mentioned in the Bible. You know, there's a word in the King James Bible that's called commonwealth. Did you know that? One time. Estates. To the firstborn son. Where did they get this idea from? The estates. I'm not saying it's biblical. I'm just saying, where did they get this idea from? They've been passing these inheritances up for years, right? Generation to generation of monarchs, rich people, barons. Pass your inheritance up. And by early years of the 14th century, the Barons Grey and D. Wilton had established themselves as the neighboring estates on the other side of the Earl of Lincoln. We do not know precisely when lawyers and students of the law first began to occupy the buildings on various estates. We do know that as late in the 13th century, the study of law remained under clerical control. capacity of clerical control. A number of events then gave rise to the growth of a colony for the housing and education of lawyers in the village of Holborn. These events included the issuance of papal bull forbidding the clergy, papal bull forbidding the clergy in England from teaching common law, and to enforce certain clauses in the Magna Carta leading the establishment of the Court of Common Pleas in Westminster Hall. Now, why are we opposed to the common law? And can you spot it in Court of Common Pleas today? Can you spot it in your courts? What categories of law fall under the common law? Jury trials, testimony, death penalty, self-defense, the basic necessities of food, right to life, liberty, the right to travel. The state says you don't have a right to travel. It's never been brought forth. And I talk about that before. Westminster. At the beginning of the 14th century, a number of small hostels for lawyers in the vicinity grew. Following the abolition of the Templars in 1312 and their subsequent persecution, the successors to their estate, the Knights of the Hostel St. John, leased it to a group of lawyers who subsequently divided themselves into four societies: intertemporal, At roughly the same time, two other groups of lawyers settled in the respective manors house of the Earls of Lincoln and Grey de Wilton, adopting the names of the landlords as the names of their societies. These societies in time evolved simple hostels into entities that would provide everything necessary for practice at the bar. Why do they have a bar? What is infiltrating the law? And why is the English Magna Carta and the Anglo-Saxon law garbage? Why do the patriots want to make up their own shit? I never understood that. They have no idea what they're talking about. I respect that. You can decide, do what you want. Why is the bar so wicked? Now, I'm not for the bar. I'm gonna tell you that right now. But why is it so far? What is infiltrating the bar? There's a story missing here. We only got one side of the story. Papal bull, the bar, including the basics of education chambers to live and work in, a hall for communal dining, and chapter and library. Or what I say, a chapel and a library. The memberships of the inns now consist of students, barristers, and benchers. Call to the bar is made by the treasurer, after which the students become a barrister. The highest rank is the master at bench, or bencher. Benchers constitute a governing entity in the inn. The benchers periodically meet as a body in the inner temple and the middle temple. These meetings are called parliaments, while the Lincoln's Inn refers to the meetings or councils, and the Gray's Inn designates them as pensions. Each inn has a number of officers, treasurers being chief among them. Now they're going to go into the word and say, oh, look, there's an arch-treasurer from the Vatican. No. The Vatican doesn't practice common law. You're taking this word out of context. I can already foresee the out of context. I already foresee it. It's already been done before. So there have been other inns established to use the judges and surgeons. Two of these surgeons' inns remain, one in Chancery Lane, the other in Fleet Street. By 1316, the order of the call, the rank of sergeant in at law had been created, consisting of the most outstanding members of the profession. The ranks of sergeant at law would exclusively produce the judges of England from the middle of the ranks. The 16th century till 1873. The surgeons also enjoyed a monopoly over practice in the Court of Common Pleas till 1847. Now they had a monopoly. After the abolition of the order in the late 19th century, judges would remain as benchers of these respective inns of court, and would no longer have to retire to one of the sergeant inns on evaluation to the bench. It was customary for sergeants to address each other as brother, hence the custom of judges of a bencher referring to each other as brethren. Now I'm gonna skip down a little bit of this because you can go read this for yourself. It's on the Inn of Court Texas site. Inn of Court boasts long historical members. Okay, it's an Inn of Court site out of Texas. I'm going to go ahead because I got a lot to do here and I'm running out of time. So it says the Inn of Court boasts a long distinguished list of distinguished members. A brief sampling, which as follows. A brief sampling. Notable members of Lincoln's Inn are Sir Thomas More. Sir Thomas More. You ever read his material? Why not? Lord Ellesmere. Sir Matthew Hale. You ever read any of Hale's material? What about Mansfield? You ever read Mansfield stuff? Lord Chancellor's Brougham, Campbell, Fortescue, I never read that. Lyndhurst, never read that. Never read Don either. William Penn, William Pitt's material I read. President Dwight Eisenhower. I don't know who this Dean is of the United States. I've never read that. Notable Inn Templars, never read Jeffrey. Sir Edward Coke, I know about that. Sir Thomas Littleton, Lord Nottingham, John Sheldon, Lord Chancellor Thurlow, I read that, and Bosler, Ellenborough, and Muhammad Gandhi, Inn of Court, Muhammad Gandhi. Notable temples include Charles Dickens, William Makepeace Thackeray, Sir Francis Drake. You ever read any Drake's material? Sir John Hawkins, Sir Walter Riley. Don't they have a Riley in Indiana? Edwin Buke, Sir William Blackstone. Have you ever read any of the common law of Blackstone? Lord Chancellor Clarendon, Summers, Hadrick. I've read a little bit of Summers, but I'm not too familiar with it. It's been a while. Hadrick, Eldon, Finley, Jewett, Lord Chief Justice Cockburn. You ever read any of the material? Coolidge. And reading additionally, we find the following Middle Templars among the signatories of the American Declaration of Independence. Inn of Court: Dickinson, Rutledge, Hayward, Thomas Lynch, Thomas N. Keene, Arthur Middleton, Howard Taft, who served as both President of the United States and the Chief Justice of the Supreme Court, was a Middle Templar. Notable members of Gray: William Cecil. I read Cecil. Burleigh, I haven't read much. I've read one article of Wikipedia. Nicholas Bacon, read a lot of that. Kiefer, never read Kiefer. Francis Bacon, read that. This Archbishop, never read this guy here. Whitgift, nope. Lord Chancellor Birkenhead, nope. Sir Churchill, Prime Minister, and Franklin D. Roosevelt, President of the United States. Check that out. Trends. Overview. The American Inns of Court are permitted after the English Inns of Court. The American Inns of Court is the fastest growing legal organization in the country. I thought the bar was. Today, there are more than 300 Inns of Court in 49 states and the District of Columbia. New inns are being organized continually. More than 20,000 judges, lawyers, law professors, and students are currently members of the American Inn of Court, including 40% of the federal judges and over 1,500 judges. In 1977, 1980, 1977, when this really started kicking off in 80, Chief Justice Warren E. Burger and the other American lawyers and judges spent 2 weeks in England as part of the Anglo-American Exchange. They were particularly impressed by the clinical approach of the English Inns of Court, and by the way the inns passed on two new lawyers to decorum, civility, and professionalism necessary for properly functioning bar. Is that happening? No. The American Bar Association said the bar's crashing. I wonder if they're doing it on purpose. Gee, the American Bar said 2004 or 5, the American Bar made a video that said the bar is destroying and crashing, and yelling and screaming at the lawyers on stage while they're not helping to fix it. And the lawyers and the bar clown said they just want for what they want and they hate the bar. The following his return, Chief Justice Burger authorized a pilot program that could be adopted to the realities of law practice in the United States. Chief Justice Burger, former Solicitor General Rex Lee, these guys are hardcore, and senior United States District Judge A. Sherman Christensen founded the first American Inn of Court in 1980. 1980. 1980. The inn was affiliated with the J. Reuben Clark School of Law at Brigham University, Young University in Provo, Marshall, Utah. The number of inns increased slowly at first, but the growth of the movement began to accelerate in 85. The reorganization of the IRS. Remember those time frames? What's going on? With the creation of the American Inns of Court Foundation. American Inns of Court are designed to improve skills, professionalism, legal ethics of the bench and bar, which is a lie. That ain't happening. The reason they ain't happening is because we got Islamic law practice in the America. Where do you think the gold fringe came from? Didn't come from the West. Didn't come from the Vatican. What was first? You ever seen the black robes? The black flag with the gold fringe flag on it from over in the Middle East and Saudi Arabia? Everything predates the United States and West because it started in the Holy Roman Empire and before and blew up and pushed out to the West. Bill Warner. Why are we afraid of Islam? 1400 years. They helped lawyers soon become effective advocates with a keener ethical awareness by providing them the opportunity to learn side by side with the most experienced judges and lawyers in the community. The objectives are of each in are as follows. Now, I'm not reading that, but you can read that. This is part of my class. They have no idea when they walk into court what's going on here. Anglo-Saxon law, Magna Carta. Where's it at here? Magna Carta. Laws of William the Conqueror. It's in here. It's somewhere. I found this. There it is. 1215. Now, what did I show you in that brief? I'll back this up just a little bit. Now, they cited the Magna Carta. They're using the Magna Carta in federal court as if this brief's going to work. And it's going to work. It's going to unset the Obama health care. I believe it's going to have profound damage on it. Whether the courts take it and run with this or not, it's going to have an effect on the court how they decide. What are you going to do? You're going to bypass all that law? Yale Law School? Medieval documents 400 to 1399, the Avion Project, documents in law, history, and diplomacy. All of this, look at this, 4000 BC, all this has to deal with Islam, and all the way to this day, Islam's involved in this. All this. They brought that garbage, that Middle Eastern law, and they brought that into our American law. They brought that junk. They perverted our law. They perverted our Anglo-Saxon law. And they kicked the king out and adopted Islamic law. When you read the slavery and the black codes in the South, yeah, that's just real bad. We shouldn't have done that. Where did that idea come from? Where did the black codes and slavery come from? Why aren't we asking these questions? Whose idea? And does Islam and Saudi Arabia to this day lay claim on those black people to this day? You damn right they do. And it was edified in that Chinese case in the 1870s, the Wak Ting case or whatever it is, where the Chinese government said those are our citizens. They belong to us. You bought those as black Africans. Those are slaves. Those are slave ship to Korah. You know the Amistad movie. Go watch it. Those belong to us. To this day, you still see them being subjugated to Islam. They're being treated as if they're Islamic chattels. To this day in the United States. The cops run around shooting blacks, and the police don't know what the Masons know this. The government knows this. Everybody knows that. Everybody that goes back and breached finally, thank God, thank the Lord in heaven for this. Bill Warner, Usama Dakdok, and Wally Schubot destroyed most or all the patriot mythology that was taught to me. In terms of the Vatican, the West, and the king, and the monarch, and all this dissent against the king, and its corporation, all this ignorant stuff. Nobody brought in the Islamic Middle East perspective as the whole part of the pie. You had half the pie. They had half the pie. And to me, listening to George Gordon, I learned a lot from George Gordon. I'm a student. I took all his classes, just about all his legal classes. I think maybe I didn't take family law, but civil rights and courtroom strategy and tax and status and business and survival subsistence and Mosaic law. And I didn't get to 90 common, but so being introduced that way with him and the stuff I did at Ohio State on my own and all the other legal guru stuff that I could find, it just was junk. It didn't make sense. Now, I'm not saying Georgia's stuff is junk. I'm saying that the other stuff that I found was, except for Ohio State, was just garbage. And you see a lot of the patriots spouting off the garbage. They don't really know. They have no idea. They're not going back to 1800s. They're not going back to 4000 BCE, 399, and asking the question, does the insurance from then, was there insurance back then? There was. Insurance was back then. Google it up, insurance, Babylon. Insurance, Babylon. It's part of my class. I put that in there. We got a huge insurance problem right now. That we adopt law and we drag that garbage from the Middle East to the United States. You know, ISIS was over there destroying those temples and those pagan statues and all that stuff. I got an international law page on my site. I'm going to start working on it. International law. Why did they do that? They're destroying international law, dragging that law. Syria. Type in a word called the home rule. International home rule. City-state home rule. Syria, Damascus, I think, was the longest city. You know where the home rule comes from? It comes from the Bible. The land of Nod. You see home rule illustrated in the Garden of Eden with Adam and Eve before the fall. And they're ejected out of the home rule, and they go and live out there in the wilderness. And Cain kills Abel, and he goes down to the land of Nod. Where did the home rule come from? It comes from the Bible. The history of the Middle East. Are we practicing the home rule? Yeah, we are. Global city infrastructure happening right now. It's on my site. Talking about the home rule. The courts have ruled the home rule can do anything they want. Where do you think the sovereign committees were killing people? A lot of it was in the rural areas, but a lot of it was in the cities. It's a home rule. People are locked up in the cities. Alright, let's move on here. Check this out. Here's another part of this. A day after, this is Wally Schubot, Schubot.com, Awareness and Action. This is Andrew Besieged, whatever, and December 4, 2015 featured. Day after Muslim terrorist attack in California, U.S. Attorney General says jail Americans do not stand with Islam. Go take a look at it. Subscribe to him. I do. So he says that. Let's take another one. Somebody else said it. The Daily Wire. Loretta Lynch vows to prosecute those who use anti-Muslim speech that edges towards violence. The day after the horrific shooting spree let me go ahead and the day after the horrific shooting spree, what appears to be a radicalized Muslim man and his partner in San Bernardino, California, Attorney General Loretta Lynch pledged to a Muslim advocacy and lobbying group that she would take aggressive action against anyone who used anti-Muslim rhetoric that edges towards violence. Well, the Bible says don't commit murder. It doesn't say kill, first of all. And the Bible prohibits self-genocide or self-suicide, meaning standing there and being your head cut off without fighting. The Bible prohibits that. It's a crime. That you want to get under God's skin, you want to piss God off, well, just do that. You want to piss God off, just give up your guns and swords and knives and hoes and sticks and rakes and K-bars and whatever. You want to do that, just give them up. Allow these idiots in the federal government to take them away from you. Allow those idiots in California, all those Jews, and I'm a Jew, so I have to say this. I got Jewish people in my descendant side in Germany. Allow those idiots to take your guns in California. Okay? Who use anti-Muslim rhetoric that edges towards violence. What does that mean? Speaking to the audience at the Muslim Advocates 10th anniversary dinner Thursday, Lynch said her greatest fear, now she's in fear mode, is an incredibly disturbing rise of anti-Muslim rhetoric in America, and vowed to prosecute any guilty of what she deemed violence-inspiring speech. We have a case here in Ohio, and I'm trying to think of the name. It's the Brandenburg case. Type in KKK Brandenburg free speech. The fear that you have just mentioned is in fact my greatest fear as a prosecutor, as someone who is sworn to protect the protection of all the American people, which is that their rhetoric will be accompanied by acts of violence, she said. Now, obviously, if I say, we ought to kill all the Muslims, and some guy over here across the street heard that, and he goes and does that, they want to prosecute me. I wouldn't say that. We don't need to do that. we need to take this class. And when there's an issue, we need to sue on it. It says, now, obviously, this is a country that is based on free speech. But when it's edged towards violence, when we see the potential for something lifting that mantle of anti-Muslim rhetoric, or as we saw after 9/11, violence directed at individuals who may not even be Muslims, but perceived to be Muslims, and they will suffer just as much. When we see that, we will take action, Lynch said. Now, I'm not going to read all this. You can go take a look at it for yourself. This is on the Daily Wire, Loretta Lynch. There's a video by James Barrett. Sorry. So December 4, 2015, Daily Wire. Here's another one. BuzzFeed says the same thing. Loretta Lynch actions will be violent talk towards Muslim, blah, 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 prosecuted. Whatever. By John Stanton, BuzzFeed News. What else we got? Oh, that's Time Warner. Here's the end of court with the videos. I'm going to exile that. I want to tell you something about this. There's an imam that was in Pakistan or Egypt or wherever the hell he was. I saved a video and I can't find it. I got to play it. And I'll tell you about these Muslims. These Muslims are in grave danger here in the United States and the West. I'm telling you. Especially a lot of those military-aged males. Where's all the women and children at in those videos? I mean, it just seems there's a lot of, most of them are men. They're running. Europe is starting to show its ugly teeth. We know what Germany can do. Germany goes clear back to the Holy Roman Empire. I'm telling you, Muslims are in grave danger from Europe. I heard an article on the way to Columbus today, listening to what Germany's doing, what they're on the precipice of changing up their military strategy and their military policy. I'm telling you, I'm warning you, if any Muslim listens to this, if you better tell people you better get the hell out of Europe while you can. Because what happened to the Jews is coming to the Muslims. I'm telling you. If it doesn't happen, then we're at the threshold of Messiah returning. But I suspect, just by knowing that Europe, the national guillotine, France, there was an article, France said they were going to bring out the guillotine. So we got these things going on. We got Islam in America. We have Islam in America, and it's in our, it's how the police practice law, and nobody really knows this. I mean, I had to vet this stuff out. I mean, on my site, there's Supreme Court pictures on some of the pages that has Muhammad and the Supreme Court. And you have people talking about that. That this is how Anglo-Saxon administration, that Islam is at the basis of Western and American jurisprudence, Anglo-Saxon administration. They had no choice. They brought in the black slaves. Man, this is crazy. We took and brought that garbage law into the United States. We had no right to do that. Now we're being cursed. But my classes reverse that. How to stop that for you specifically. That's important. Alright, this is the Craig Kirk School of Law. And this is kind of an intense thing here. And I want to put this together in these sequences to kind of give you an idea of what trends are happening. What trends. When people need to know these things. Alright, well, we're going to go ahead and conclude this. If you are interested in the class, take the class. Call for the classes, email me, whatever. Go to the site, contact, go to craigkirkschooloflaw.org. craigkirkschooloflaw.org. Phone number 740-824-4850. And with that, brothers and sisters, I hope this has been educational and informative. And we got to look at these trends. And I'm always paying attention. So I'm going to go ahead and we're going to disconnect here, and we will catch you probably tomorrow night or whatever. And got a lot of work, so we're going to be hitting the classes. You know what I didn't do? I made an error. I guess I'm going to do this. Federal objections, federal trial objections. Quick reference card. My fault. I'm going to go ahead and stop that, and let's go into some of these objections, okay? This is part of the class. Objections to the form of questions. Objection, ambiguous. Objection, argumentative. Has been. Objection, asked and answered. Objection, assumes facts and not an evidence. Objections, badgering. Objections, too broad. Objections, compounding question. Objection, offer to compromise. Objection, conclusion. Objection, confusing question, which is a cross question, like cross objections. Objection, exceeds the scope of direct. Objection, guilty plea offers to plea. Objection, harassing the witness. Objection, hearsay. Objection, improper hypothetical. Objection, cross. Objection, leading questions. Objection, misleading question. Objection, misquoting witnesses. Objection, misstating facts. This is common right here. This right here, this is classic. God, this is more classic. This is called fact pleading. Objection, misstating facts, not an evidence. Misstating the facts. Objection, multifarious of question. Objection, narrative answer. Objection, overly broad. Objection, repetitious. Objection, speculative. Objection, unfairly prejudicial. Objection, unintelligibly vague. Objections based on evidence. Objection, limited admissibility. Objection, irrelevant. Objection, its probative value is subsequently outweighed by the risk of unfair prejudice. Objections to responses. Objection, refusing to answer. Objection, being argumentative. Objection, hostile. Objection, answering the narrative. Objection, non-responsive. Objection, witness lacks personal knowledge. Objection, being unresponsive. Objection, volunteering information. Hearsay exceptions. Absence to entry in records. They do this all the time. This is nobody. You know, they don't really. People don't really object to this. This happens all the time with governmental records, driving records, suspensions. They do this all the time, and they say this is legal, and lawful. And then they tamper with governmental records by putting on there, knowing it was a crime to do that. You can't consent to that. It's a lie. You can't commit perjury. That's where the civil rights lawsuit comes in. Okay, I'm charged with a crime over here. Maybe I can't win. But because you did this, I can sue. It don't matter. Tit for tat. Boom, bing, bada boom. Absent of public records objection. Ancient documents objection. Baptismal certificates objection. Either for or against it. Records. So you can see this. I'm going to scroll down here and you can see some of the objections. Here's expert witness and opinions. Expert not qualified by knowledge or skill, training, or education. You know how many times this happens? Police officers do this. They do this. The car is unworthy of being on the road, but the police officer is not a automotive expert, and because it looks something does not mean it's unworthy of the road. Rust does not describe on a car, does not describe that the car is unfit or unsound. Claimed field or expertise is not generally recognized as a scientific, technical, or otherwise specialized discipline. Police are not electronics equipment major. You can go right on YouTube and how to use electronics and multimeters. If you can learn that, you can go into court and argue a police officer about the equipment and the electronics in the car and have records. You can't just make up a lie that the electronics in the car is good. We'll prove that. You can't just make that up. They try to do that. That's an appealable issue. That's due process violation. It's part of discovery. Unpermissible opinion. There's an objection. United States Supreme Court authority. So you can read that. Permissible. Write these down. This is part of the class. So I'm going to scroll down. You can see these. Electronically stored information objections. Multiple forms of production requested. Objection to form in which information was requested. Unduly burdensome or not reasonably accessible objection. Ancient documents. You know, a birth certificate, the original birth certificate, is an ancient document. Is it admissible? Is a copy admissible? Who's going to testify to a birth certificate? Who's going to have first-hand knowledge to testify? Well, it's what we got here. Well, now the burden shifts to who? Me or you? 2006 notes of the advisory committee. Common privileges. Marriage privilege, marital privilege, physician patient, brain shrink doctors and patient privilege, work product privilege, other privileges. Unreasonable cumulative or duplicative, untainable from another source. Ample opportunity, burden or expense objections outweighed benefits. Business records, safe harbors for sanctions, good faith loss, transmission of privileged documents. Character evidence, non-testimonial trial objections. You can read this for yourself, look at the video, write it down. God, I need that. Well, this is part of the class. This stuff's in the class. And I go through all this material, and I talk about objections I made and how to spot objections across objections and just twist them all up. And do it righteously, too. Confrontation clause, sexual predisposition, rape shield. This is disgusting here, but confrontation clause, Gills versus California. There's objections there. Method of proving character. So you can see that, and you can just simply stop the video and look at it and read it. And I'm going to scroll back up here to the first page. We're going to go over the first page again. Best evidence, bolstering, confuses the issue, objection, confrontation clause. Where does this come from? This confrontation clause. This is a common law question. Where does this come from? You know this isn't in the Bible. Cumulative, hearsay, hypothetical, impeachment, improper, character evidence, improper, predicate, irrelevant, misleads the jury, objections, opinion. You got to pay very close attention. Opinion, testimony, other wrongs or acts, parole evidence rule, pleadings, prejudicial, pretrial order objections, privilege objections, compensatory rule objection, proper foundation laid, there's an objection, could be, settlement offer, speaks for itself objection. Speculative, undue delay. Prosecutors do this all the time too. That way they get you on discovery, and that way you can't hardly go in there and defend and write this stuff out. They do this against the public defenders. You know, it's a form of due process violation, too. All right, this is the Craig Kirk School of Law, and I hope this we're going to finally conclude this. This is 10:23. And with that being said, I'm going to go ahead and disconnect here, and I'll catch you probably tomorrow night or whatever the schedule says. I got to look at the schedule. But so with that, brothers and sisters, if you're interested in taking the classes, let's see here. Oh, that's the other one. I'll go ahead and X that out, and let's go ahead and shrink this down. Let's see, law class. Here's the classes. You can see what's in here. Trial notebook, pleading, co-pleading, legal research, and public records. Right now I'm in some serious public record stuff in other areas. Extraordinary remedies, comity, grand jury. There's 29 chapters in this class. This is 3 weeks long with videos. I'll give an example. Statutory construction. Go to recordings. See, there's videos in here. These are videos. This is 1, 2, 3, 4, 5 hours. Let's go to inmates' rights, chapter 10. Go to recordings. Oh, no. Videos. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12 hours. This is important. The reason there's so much here is because you got to know. I got to know. I'll tell you what I discovered. There's 12 plus hours here just on inmates' rights with MP3s. MP3s. videos. I go through all of them like I'm doing right now. Alright, this is the Craig Kirk School of Law. I am out of here. We are done. I'm going to X out. And we are concluding this show.